Good morning, this is your Kelso Report for Thursday, February 7th. I'm your host, Clark Kelso. We begin with a federal habeas case that explores what it means for federal law to be clearly established. And then we have two state arbitration cases, both involving the question of whether an arbitration clause is unconscionable, and they reach opposite conclusions. Good example of the difference between an unconscionable clause and an enforceable clause. We begin with the Ninth Circuit. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, a federal court can grant habeas relief only if the last state court decision on the merits was contrary to or involved an unreasonable application of clearly established federal law, as determined by the Supreme Court, or was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Now, as we all know, the law tends to develop incrementally from one case to another, and it is often a close question whether the reasoning of a case should be extended to the next similar situation. Depending upon how narrowly or broadly one reads a case, the next step may be clearly established or not so clearly established. It is often all a matter of degree. A good example is found in the Ninth Circuit's decision in Smith v. Hedgepeth, where the petitioner sought habeas relief on the ground that his conviction for assault with a deadly weapon, coupled with a great bodily injury enhancement, was in fact a lesser included offense of his conviction for infliction of corporal injury on a spouse, which also was coupled with the deadly weapon enhancement, thus, according to the petitioner, violating the double jeopardy clause. A number of Supreme Court cases seem to be relevant to this issue, including Apprendi v. New Jersey, Texas v. Cobb, and Satizan v. Pennsylvania. The closest precedent, Satizan, was distinguished, arguably on the sole basis that the decision in that case arose in the context of a death penalty. All parties agree that if the language in Satizan was simply extended to a non-capital context, well, then the federal law would have been clearly established. But even that seemingly small step was enough to make the federal law not clearly established for purposes of habeas relief, so the Ninth Circuit denied the petition. In essence, the court holds that Supreme Court precedent must be on all fours for federal law to be clearly established for federal habeas purposes. That's, of course, a tough standard to meet. Well, now we have two arbitration decisions from the state courts. The United States Supreme Court has made it crystal clear that a state may not adopt special rules that are antagonistic to the enforceability of a contractual arbitration clause. Interpreting the Federal Arbitration Act, the Supreme Court has made it clear that a state may not shape or bias its doctrine of unconscionability, so that there is an absolute bar against the enforceability of arbitration clauses in consumer or employment contracts. At the same time, if an arbitration clause actually is unconscionable, using neutral principles of the law of unconscionability, well, then a state can refuse to enforce that clause, just as it can refuse to enforce other unconscionable clauses. In Natalini v. Import Motors, Inc., the First District held that an arbitration clause in a contract between a consumer and a car dealer was unconscionable and unenforceable. Procedural unconscionability was, as usual, rather easy to find, since the arbitration clause was offered on a take-it-or-leave-it basis, on a form contract, was not negotiable, it was inconspicuous on the back of the contract, and the consumer did not even have the opportunity to read the contract before signing it. But I think the key to the court's holding was its finding of substantive unconscionability, which was based on the fact that the arbitration clause contained a number of completely one-sided provisions favoring the car dealer over the consumer. For example, The provision authorized an appeal, resulting in a new arbitration before a 3-arbitrator panel, but it was only for an award of $0 or in excess of $100,000. That provision strongly favored the dealer, because the buyer's maximum liability under the contract was only $92,000, while the buyer's liability was likely to be, the seller's liability was likely to be in excess of $100,000. Several other provisions also benefited only the dealer. So the First District refused to compel arbitration, finding the arbitration clause to be procedurally and substantively unconscionable. Well, the analysis in Natalini can be nicely compared with the analysis in our next case, Bigler versus the Harker School, where the Sixth District upheld an arbitration clause in an enrollment contract between a private school and the parents of a student. This was in the context of a tort action by the student against the school and one of its teachers. The student had been accused of an honor code violation, and when they couldn't resolve it amicably, sued the school and the teacher who made the accusation of the violation, asserting that the accusation was mistaken and wrongful. When the school tried to invoke the arbitration clause, the plaintiff refused, and defendants then made a motion to compel arbitration. The Superior Court held that the clause was unconscionable, but the Sixth District reversed. It concluded first that there was no procedural unconscionability. The clause was clearly labeled on a short, only 2-page enrollment contract. It was on the back, but it was clearly set aside in a separate paragraph. There was no evidence the clause was a surprise. It apparently had been in the contract for years. And no evidence that the clause was actually non-negotiable. The court's sense was a school probably would negotiate that if a parent objected. In addition, the clause contained none of the one-sided provisions that existed in Natalini. The clause instead imposed mutual obligations to arbitration and contained no one-sided exclusions. So the Sixth District held the clause in this case was valid and enforceable. The two cases here are a nice example, in both cases, of what it takes for a contract, an arbitration clause, to be found unconscionable and unenforceable, and by contrast, what sort of an arbitration clause is likely to be found valid and enforceable. And that's it for today's Kelso Report. Have a great day in the law.